Welcome, everybody. So glad to have you today. Real exciting. We got another round of public hearings today. And we thought today, or maybe going forward, we'd like to just recite the preamble of the Constitution. That's a really important part of what is driving a lot of what we're doing and how this is formatted. So I'm just going to go through that before we get going. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. So welcome to the January 20th session of the Phoenix Congress, where we are writing a blueprint for a better America. Today's session is the second of 21 public hearings on the 2022 legislative package, and we will review sections 114 and 115. The legislative provisions include restricting the use of chokeholds, reducing the burden of proof for civil rights prosecutions from willfully to knowingly or recklessly, and requiring law enforcement to use de-escalation techniques before using force. These sessions will alternate between Mondays and Thursdays at 1:30 p.m. Eastern through March 28th, 2022. For those following along at home, you can find a link to the legislative package in the description below or at bit.ly/B, lowercase Dropbox. If you'd like to submit a question in the chat, please indicate which of today's sections it applies to. And if you'd like to offer questions or other testimony for future hearings, please use the link in the description below. With that, I'd like to welcome the delegate from North Carolina's 4th District to continue his testimony on the blueprint for a better America.
Thank you, Mixed Chair. For the record, my name is Brian. I'm an organizer with the American Union and a Phoenix Congress delegate in good standing, representing what's expected to be North Carolina's 4th District in the 2022 election. And like you said, the preamble for the Constitution, the 5 duties in there drive this legislative package. And so today we're continuing our look at how we can better establish justice in the United States by getting back to that constitutional duty. And so the first section I'd like to talk about today is section 114, titled Restricting the Use of Chokeholds. And it has 3 subsections, A, B, and C, and I'll just talk about each of those briefly. The first is, this is the Eric Gardner Act. And for those who don't recognize the name, he was a man in New York City in 2014 that it was caught on tape as he was put into a chokehold, passed out on the ground, and left there until ended up passing away as a result. His cries of "I can't breathe" were ignored, and it led to a lot of protests years before the George Floyd murder. And in this case, he was allegedly selling loose cigarettes. Matt Taibbi wrote a book about this incident called "I Can't Breathe: A Killing on Bay Street," and he deconstructed the circumstances that led to Eric Gardner's death, and concluded that basically the police had been told, "Hey, go clean up this corner, go arrest some people," and despite there not being any evidence that Eric Gardner had been doing anything, they tried to arrest him and choked him to death when he didn't comply. And so this section of the George Floyd Justice Act is titled in memory of him. So chokeholds, neck restraints, they fall into 2 broad categories. So the chokehold, which restricts the airway when pressure is applied to the front of the neck, and then a stranglehold, which would restrict the blood to to the brain when pressure is applied to the side of the neck. And these have been controversial for a long time. In fact, many states and many municipalities have banned them. In fact, New York Police Department banned them back in 1993. Since then, they're banned in other states like Connecticut, Florida, New York, California, Wisconsin, Washington, in Washington, D.C. And so Part B of this section puts limitations on the eligibility for funds that states can get unless they have a law that prohibits law enforcement officers from using chokeholds or cartoroid holds, as described in this act. And that provision would go into effect for the 2025 fiscal year. So they would have until till the end of September 2024 to ensure that they had such law on the book in order to continue to qualify for the Burn Grant Program or the COPS Grant Program, as we talked about last week, which are some of the main ways that the federal government sends police funds to the states. Section C, subsection C of this act puts that same prohibition on using chokeholds into Section 242 of Title 18 United States Code, and it would make it a civil rights violation to use those. And that pretty much sums up what I have to say about the chokehold parts of this section. But there's another part about upgrading Section 242 of Title 18. And my testimony in this part is going to rely a lot on a policy report by the Brennan Center for Justice that they issued last April, titled Protecting Against Police Brutality and Official Misconduct. And so the other thing that this section does is it changes the standard for a prosecution under this from willfully to knowingly or recklessly. This is the section of law that federal prosecutors can use to bring criminal charges against government officials acting under the color of law for violating civil rights. This is the law that the police officers in the George Floyd murder are being charged with right now. And they have a higher burden of proof, willfully. The prosecutor is going to have to prove that they willfully violated his rights. A little bit of history on this law. This is one of the many Reconstruction pieces of legislation from Reconstruction after the Civil War under the authority of the 13th, 14th, and 15th Amendments to the Constitution to protect the civil rights of the former slaves, and as they began to exercise their rights as free citizens of the United States, there were many violations of those civil rights. And so Congress passed this law, and it was used to prosecute for a while. But in 1945, there was a case that sort of changed the way the prosecutors used it. That was the case of Screws versus the United States. And it was the Supreme Court ruled on this, and I'll just kind of paraphrase from their description of the case. And they said the case involved a shocking and revolting episode in law enforcement. The petitioner was the sheriff of Baker County, Screws, the sheriff of Baker County, Georgia, and there was some evidence that he held a grudge against Robert Hall, a young black man of about 30 years of age. And so Sheriff Screws got a special deputy and a policeman, and they went to arrest Robert Hall late one night on the charge of theft of a tire. And so they handcuffed him, threw him in the squad car, took him to the courthouse. And when they got him out of the car, they began beating him with their fists and with a solid bar blackjack, about 8 inches long, weighed about 2 pounds. And they beat the handcuffed man for 10 minutes, 15 minutes, 20 minutes, 30 minutes, until finally he was unconscious. And then they dragged him by his feet into the jail, threw him on the floor, and left him there. And like Eric Gardner, 70 years later, uh, eventually, an ambulance came, but it was too late. The man never regained consciousness and was dead and died within an hour. And so Sheriff Screws was charged and prosecuted for this murder and was convicted, but he appealed it all the way up to the Supreme Court. And the Supreme Court overturned his conviction and said, quote, in view of our construction of the word willfully, the jury should have been further instructed that it was not sufficient that the petitioners had a generally bad purpose. To convict, it was necessary for them to find that the petitioners had the purpose to deprive the prisoner of a constitutional right, e.g., the right to be tried by a court rather than by ordeal. And in determining whether that requisite bad purpose was present, the jury would be entitled to consider all of the attendant circumstances, the malice of the petitioners, the weapons used in the assault, its character, its duration, the provocation, if any, and the like. And so because they felt that there wasn't sufficient evidence that they willfully intended to deprive him of his right as they beat him to death, they overturned the conviction. And since that time, this higher standard has led to less prosecutions under this section of law. And so Section 114 of the George Floyd Justice Act, which is this section is also taken from the George Floyd Justice and Policing Act passed by Congress, by the House last year. It would replace willfully with knowingly or recklessly. And this would change the burden of proof that jurors would have to, the prosecutors would have to meet in order to convict someone of a crime. Under the standard of willfully, the jury must find that the defendant acted with knowledge that one's conduct is unlawful and with the intent to do something the law forbids. But if under the standard of knowingly, it's only necessary to conclude that the defendant acted knowingly, that it was done intentionally and voluntarily, and not because of ignorance, mistake, accident, or carelessly. And then the standard for recklessly is the jury must find that the defendant act while consciously disregarding a substantial and unjustifiable risk that the material element exists or will result from his conduct. And so with the inclusion of the specific prohibited conduct in the proposed statute, by changing those standards, it would reduce the level of intent required for a jury to find a defendant guilty for engaging in prohibited conduct under Section 242 of Title 18. Yeah, I guess I just want to, it's federal law was there for a reason to help make sure that violations of our civil rights could be prosecuted, and to the extent that they are falling through the cracks because of this higher standard affirmed by the Supreme Court, it is appropriate for Congress to step in and bring it back to where this law can be used to protect American citizens from abuse of authority under the color of law. And Mr. Chair, I guess that concludes my testimony for Section 114, and I'd be happy to answer any questions.
Fantastic. Yes, we have a question from Danilo in Wisconsin. The use of chokeholds would prevent the loss of life of an officer and maybe even potentially a subject, because we know that using a chokehold would probably be less lethal than overcoming the resistance by using a firearm. There's no question mark in this question.
No, I mean, but there's clearly some truth to that. That a chokehold would be probably less less deadly than using a firearm to subdue someone. Is that a justification for leaving this practice open? I guess I should say that in New York City, when they banned chokeholds, they left in that same. I'm going to use the word loophole. I'm not sure that's the most precise, but I'm going to say loophole, that chokeholds could be used to protect the life of an officer. And the issue with leaving the loophole in place is that it opens the door for the use of this dangerous technique. And so is there zero risk that you could, if you ban this, will that lead to zero risk for officers? No, there's never a zero risk of anything. You could maybe make an analogy of like seatbelt use and say, well, sometimes people don't wear their seatbelts and they're thrown free of a car. So maybe you shouldn't encourage people to wear seatbelts. Well, statistically, you're much safer wearing a seatbelt. And by banning chokeholds, statistically, you will reduce the loss of innocent life. And so that's the direction that we should go in our quest to establish justice.
I have two questions. So in subsection C, you are adding the language, the application of any pressure to the throat or windpipe which prevent or hinders breathing or reduces the intake of air. They seem inconsistent. You've got prevent or hinders. Why would it not be prevents with an S at the end?
That's a good question. You're probably correct. Yeah, it should probably be prevents. Or if you look at the rest of the statute, maybe it should be prevent, hinder, and reduce. We can look at it in subcommittee.
The application of any pressure to the throat or windpipe which prevent or hinder breathing. I would say S is on the ends of all of them, but either way.
I'm looking at the rest of the items in the list. And so the next one is use of maneuvers such as carotid artery restraints that restrict blood or oxygen. And then the next one is use, attempted use, or threatened use. So I think prevent or hinder, I think those match. And I've lost power here, so it's a little darker. That's why.
No problem.
Okay.
And the number two, didn't President Trump already ban chokeholds in 2020 after George Floyd's murder?
The short answer is that he issued an executive order that required states to pass such a law. But as you know about executive orders, is they're not laws; they're executive orders, and so they can be redone. And for consistency and simplicity, it should be codified into law. He also, in that same executive order, I believe, started a police misconduct registry, which we'll talk about later this month, and should be expanded. But yes, he did take some executive action in the months after George Floyd's murder.
Seeing no further questions, section 114 is assigned to the subcommittee on the George Floyd Justice Act. You may proceed to your section 115 testimony.
All right. So section 115, police exercising absolute care with everyone act. And you could probably guess by that flowery phrase that it's supposed to stand for something. And so the short title is the Peace Act of 2022. And I think we talked about this a little bit at the last session about requiring de-escalation. And so let me just kind of go through this section. In short, it would require, I would say it standardizes 3 levels of first, police officers would be required to try and de-escalate confrontations with people before escalating to less lethal force. And then if less lethal force and other alternatives had been exhausted, then deadly force would be an option on the table. And we'll go back to our definitions of what these things are. And we talked about deadly force means force which a reasonable person would consider likely to cause death or serious bodily harm, including the discharge of a firearm, a maneuver that restricts blood or oxygen flow to the brain, including chokeholds, strangleholds, neck restraints, neck holds, and carotid artery restraints, and multiple discharges of an electronic control weapon. So multiple uses of a taser can be considered deadly force. And less lethal force is just a simplified version of that. It's defined as any degree of force that is not likely to cause death or serious bodily injury. And so that would all right, so not later than February 28th of 2023, the Attorney General will provide guidance to federal law enforcement on the types of less lethal force and deadly force that would be prohibited under this section, and offer guidance into how federal law enforcement officers can assess whether the use of force is appropriate and necessary, and how to use the least amount of force when interacting with certain at-risk individuals. Those include pregnant individuals. I'm not sure if we talked about in the qualified immunity discussion last week, the pregnant woman who was tased multiple times and sued the police officers only to be told that they had qualified immunity for that. Children and youth under 21 years of age. You know, this can really be a traumatic thing for a child, as we talked about the pointing of a gun at them. And you know, unless there is absolute necessity for it, that sort of thing would be prohibited. Don't point guns at kids. Don't point guns at anybody if you can avoid it, right? Elderly persons. I think we saw, many of us remember the video from the George Floyd protests last year, the elderly man in Buffalo, New York, who attempted to talk to some police officers and was shoved to the ground and lay there bleeding from his skull. Roman 4 is persons with mental, behavioral, physical disabilities or impairments. Unfortunately, to the extent that we use police as first responders to people who are having mental health issues, it is especially important that we offer additional training on ways that they can de-escalate those situations and not respond with force. Roman 5 is persons experiencing under the influence of drugs or alcohol, and again, when people aren't making rational decisions, they're not in the right state of mind. It's always best to try and avoid escalating the situation. Also for persons suffering from serious medical conditions and persons with limited English proficiency. Again, miscommunications lead to tragic accidents sometimes. And again, so let's this section would require that federal law enforcement be trained in how to avoid escalating interactions with people in these situations. This section would also create a defense to charges. I'm sorry, it would prohibit a defense to any charges of murder that the officer's use of force was inconsistent with these. So, in the case of George Floyd's death, for example, if the officers are charged with murder, they would not be able to defend to say that I got this tangled up here. That the officer's use of such force was inconsistent with the de-escalation provisions of the section. And then once again, this section would put the same, offer the same carrot, use the same carrot and stick approach to the states, requiring states to implement these same training procedures for state and local members of law enforcement, and once again withhold burn grants and cop grants beginning in the 2025 fiscal year if they did not have a law on the books that met these standards. I just, as I've worked on this, I was thinking about it recently, where we saw that case in California, where there was a man having a mental health situation in a sort of Burlington coat factory, and the police went charging in there and shooting and killed some innocent girl in a dressing room because the first thing they jumped to was firing off their guns. And so it's really important to change that model of behavior and try and train them to higher, better standards. And so that brings us back to the title of this section, the Peace Act of 2022. I think, Mr. Chair, I think that concludes my testimony on section 115. Be happy to answer any questions.
Yes, I have a question. You had specifically mentioned discharging an electrical weapon multiple times. Is that correct so far? That was.
Yes. So that's included under the definition of deadly force. So yes, that could be considered deadly force.
Okay. My concern is kind of the specific situation of shoot a taser and it misses. Does that count as a discharge under that? Is that a tally under there? And I have a follow-up after that too.
The use of tasers is not my specific area of expertise, but my understanding is that for the taser to work, like there's got to be something for the electricity to pass through. And so if you shoot it and it doesn't hit anything, I don't think the electricity goes through.
The electricity does not hit the person, but there is a firing of the weapon to shoot the pins out. So you're saying that you would not count that as a discharge under that definition. So the discharge must include actually electrocuting a person then.
Trying to see, let me find the definition again here. Yeah, I think it says an actual discharge of multiple discharges of an electronic control weapon.
I think the term discharge could be interpreted to mean the firing of the pins even if no electricity is discharged, because it is a different definition of discharge in terms of like firing a weapon. So it might be worth changing that definition to specifically mention actually electrocuting a person to add clarity to that. And then the follow-up to that would be sometimes, or if you discharge the electricity, so you electrocute a person, and then they're complying at first, but then they stop complying, but they still have the pins in them. If you were to shock them again, that all of a sudden has now shifted from being less lethal to deadly force under that definition. Would that be correct?
Yes. And so we'll go back to B, subsection B, number 3, the prohibition on use of deadly force. So a federal law enforcement officer may not use deadly force against a person unless the form of deadly force used is necessary. So it would need to be necessary to shock the person multiple times another time, as a last resort to prevent imminent or seriously bodily injury or death to the officer or another person. So if it's necessary, it would be necessary to prevent serious bodily injury. Then B is that that use of deadly force creates no substantial risk of injury to a third person. Shocking someone with a taser multiple times shouldn't harm any innocent bystanders. And then C, reasonable alternatives to the use of the form of deadly force have been exhausted. So if you tried it once and it didn't work, then you have exhausted the less lethal force alternative.
And maybe you could use pepper spray or something. If that hasn't worked, maybe try something else. I see what you're getting at. Okay. Seeing no further questions, section 115 is assigned to the subcommittee on the George Floyd Justice Act. I'd like to thank the delegate for his testimony.
Thanks. It was good. We get 19 more of these to go, but there's a lot of really important policies and issues in here that deserve more attention.
Absolutely. Well, the next session of the Phoenix Congress will be held on Monday, January 24th at 1:30 p.m. Eastern Time on sections 116 and 117. This hearing is adjourned.